family members were interviewed for the inquest project, and 13 family members who had made a referral to a fitness to practice regulator like the NMC or the BMA, anybody who had made a referral and it had gone to a fitness to practice hearing, which fitness to practice hearings from referrals are an absolute minimum number. It's like 1% or something. It's a tiny amount that actually get to the hearing. And there's so little research done on this area. But there's got two different inquests, two different contexts, the inquest, and then you've got the fitness to practice hearing, really different contexts, but there's clear overlaps in the experiences of people within these two processes that directly relates to epistemic injustice. Okay, so for the fitness to practice data, if a professional conduct falls below a certain standard, staff may face a misconduct hearing. And the person who's made the referral or the person who's caught up in this misconduct or potential misconduct will be expected to become a public witness. And most referrals are made by members of the public.
There's no presentation.
Oh, sorry, there's no slides. Sorry, I can't stand doing the PowerPoint slides, so now I just don't do them. So we know that the public have a strong role to play in these processes. It's a real public interest activity to get involved in a fitness to practice hearing. Inquests, you have less of a voluntary role in some respects, but there's a very strong motivating factor for family members to get involved in both. Okay. So within the inquest project, there's a tension generated by the coexistence of attempts to put families at the heart of the coronial process and technocratic processes. And we conclude in the paper that families, whilst there's talk about putting families at the heart of the process, at practice this doesn't happen. And entangled within the fitness to practice process and the inquest process is ignorance, which has been described as a substantial epistemic practice that demands examination. So in the coronial processes, therapeutic jurisprudence, I think that's how you say it, involves and intersects with practices of epistemic justice and power sharing between the coroner and officers, relevant institutions such as an NHS trust, legal councils and families. So there's a strong recommendation that families should be at the heart of this process. Recommendations include the provision of clear and timely information about court processes, allowing families to know what to expect, keep expectations sort of met, having a key contact person to update families on the progress of the inquest, and forewarning of potentially distressing evidence, and the provision of court-based counselling services. As somebody who's been through an inquest process myself, I can tell you that certainly that back in the day, none of those existed for us. And I think they're probably quite rare now. And there's pockets of good practice around the country. These things aren't really rocket science. Providing information and keeping people informed about where a process is at, forewarning that you're going to hear distressing information is not, these aren't things that you need to have some special fancy degree or expertise to know about. These are basic aspects of human decency. Now, interestingly, Fricker, who came up with the epistemic injustice, sort of coined the term, she argues always start from marginalised, which I completely agree with in terms of research, because it's the marginalised people who hold a distinct epistemic advantage, although it's important to note that this isn't an epistemic privilege, because they know better, they can see more clearly, and they have fewer reasons to invest in maintaining the status quo. And arguably, families caught up in these catastrophic sort of atrocities, really sometimes events, can have a greater clarity about the inherent inequalities. So families don't stand to benefit from the ways in which coronial or fitness to practice processes currently work. They benefit the registrant who might be experiencing fitness to practice hearing, or they benefit the NHS trust or the police authority or the army, say, what the public sector bodies who are caught up in this. Families do not stand to benefit, but they actually tend to a lot of the work in getting these processes to be as accurate as possible and in search of accountability. And this isn't recognised, which is an inequality in itself, and it's deeply unfair. Now, if you look at families of autistic people or people with learning disabilities, there's a whole lifetime of epistemic injustice before they reach the point that they've died of probably a preventable death, or if they're caught up in a fitness to practice hearing, and families would have had to do an awful lot of labour to try to get the sort of support that that person is entitled to, and that speaks to Lucy's talk, really. So they've experienced epistemic injustice before the death of the relative, which offers insights into the operation of power at micro levels and how this translates or transfers into coronial processes. However, too often, coroners aren't interested in what came before, and they don't understand the particular situation of being a person with a learning disability. So they come in with their expertise in inverted commas without actually understanding anything about the lives of people with learning disabilities or autistic people and what they may have experienced along the way. And we know from other research about inquest processes that families can experience a sense of foreboding, the communication isn't there, you have to fight to get an Article 2 inquest engaged, communication can be poor, the time taken to hold the inquests can stretch to months or years, and fitness practice processes can similarly drag on. We had people in our study who said, I would never make that referral again, which is quite shocking when you think the point is it's to improve standards. But they said, and one person in our study whose baby had died and she went through an NMC fitness to practice process around the nurses involved or the midwives, she said that that experience was worse than her baby dying, which makes you wonder how these legal processes can be so poorly designed and delivered. So both contexts are contested epistemic arenas, and families tend to be dissatisfied with the way in which they unfold. In inquest terms, the coroner may not go far enough in terms of the scope. If you've got somebody who's died and you know that their death could be foretold 2 or 3 years earlier through a set of failings that the parents have raised, documented, all the rest of it, the coroner may sort of say, well, I just want to know what happened just at the point when they died, and reduce the scope of the inquest to that, which can leave families feeling very unheard and feeling that they're not getting any sort of accountability or answers. There are overt, subtle and mundane mechanisms within both contexts that silence families, very effective mechanisms. And if you speak up against these mechanisms, you can come across very much, you can easily gaslight, say. It's very easily to paint people as slightly unhinged, grief-stricken, and so on and so forth. So families are in a really particularly sensitive position in these processes. And families can experience insensitive and adversarial actions of legal representatives and court formalities, experiences that leave participants so dissatisfied they wish they'd never got involved. There's also more positive that families can think that the inquest worked well, or the fitness to practice hearing, they can feel that they got accountability. And again, this relates to tiny measures on the part of the coroner, the fitness to practice staff, just listening, keeping people informed, being kind, remembering the person's name, recognising that you might have been harmed through some sort of medical mispractice or malpractice. Again, really not difficult things. So we found little evidence of kindness and empathy in both projects. We found that parents are expected to endure patterns of violence or try to repair experiences of violence or redo the violence to try to repair their own narrative identities. And there was a lecture a week ago with Mairead Enright. I don't know if it's available online. It's absolutely a banger of a lecture. She talks about the family as a site. She was talking about public inquiries, the family as a site of emotional suffering. And families are also expected to absorb the burden of care, of being somehow responsible to make sure this process gets to a sort of legitimate end, even though it ends up not the end that you want it to. So for Enright, legacy, she calls it legacy work, really, and it involves repairing damaged identities. Families are forced to interrupt, disrupt, reclaim their loved one who's become invisibilized through these processes. And they take on the burden of working until the truth is laid bare. although the truth, as we heard from Lisa, can be mired in all sorts of very effective obstructions. So Lindemann Nelson, in about 2000, I think, wrote a book about counter stories and narrative damage. And she talks about counter stories of definition that work to redefine a story that's been incorrectly characterised. And for anyone in the room, Lucy maybe touched upon this, who's had their story incorrectly characterised, it's an incredibly deeply wounding experience, and it can be very difficult to move beyond. So you have to, if your story is not listened to in these settings, if it's taken from you, changed, redacted, or ditched, even, as I'll come on to say, you can feel incredibly harmed by these processes. And it can be so important to redefine that story and reclaim your loved one, I suppose. We found that in the inquest process, parents felt that their epistemic position was frequently undermined, as professionals just did not think they had any expertise to contribute to the process, which is really interesting, isn't it? And speaks again to the first presentation around not listening, this sort of like refusing to see who is the expert. And then one person sort of said in our study, about how important it is to families just want the change. They're the people who actually want the change. And this person said, you know, we're not like an inconvenient thing that the coroner might have to talk to or not. So your role is so contested. You are so invalidated within that space that you don't even feel like a human within that setting. And yet this is your core. This story is at your core. Families come to these processes almost inevitably as novices. It's totally unfamiliar space, and yet they're surrounded by people who are so familiar with those processes they don't understand the implications of their actions, and that's a really destabilizing position to be in. Disadvantages can be compounded by the autonomy of the coroner, the lack of a standardized approach. These coroners vary across the country, as we've seen from George Julian's inquest reporting. Coroners' attitudes can appear rush, rude, dismissive towards the family. And we found, which was really interesting and sort of unexpected, that legal counsel can also generate barriers. So if families do have legal counsel within the coronial process, that can create a disconnection between the family and the process. And families talked about, well, we didn't understand how to deal with our counsel. And they would say things like, could you instruct me? And the families sort of, what shall I instruct you with? And somebody said, it's like having a computer without a manual, because they would ask questions of the family that the family just didn't understand what the question was. And we had experience of that too, with the whole sharing of Post-it notes during my son's inquest, which now seems almost comedic, of this, like sort of us putting up Post-it notes with question marks on over to our counsel, who were excellent, but we still were totally at sea with the whole thing and had no idea. And this leads to further epistemic marginalisation. So the epistemic landscape in both these processes can be dominated by experts who exercise their epistemic privilege regardless of how knowledgeable they are. Now, what a banger of a thing, isn't it? Just go and exercise your epistemic privilege and make out like you know stuff, and you don't know that stuff. That is quite an extraordinary confidence, isn't it? It's quite an extraordinary, we were talking about performance earlier, weren't we? That performance of, I know best, you know nothing, and let's carry on in that sort of like dynamic. There can be misunderstandings about the person who died and their support needs when they're alive. And these misunderstandings, these assumptions seep into the evidence and potentially impact the outcome, which is quite, again, extraordinary. A lot of this stuff just baffles me, really. Integral to this ignorance was a perceived evaluation of the person within both contexts. Outcomes, like I say, were based on spurious evidence. They weren't based on evidence that would hold any light amongst people who have this knowledge, and much legal gaming amongst legal counsel who have a whole set of techniques and strategies to destabilise these processes, and they're quite extraordinary once you recognise them. And one person said to us, I think the coroner was just really arrogant. I don't think that they understood my son and just couldn't be asked. This is an inquest process, and you actually sort of feel like, well, the coroner just couldn't be asked. It's as basic as that. It's as disrespectful as that. So, as I've said, participants often shoulder the burden of providing relevant evidence to try to get answers. The aftermath in both contexts was one of exhaustion, disappointment, and feeling drained, plus an ongoing commitment to fighting more to get accountability. So there's this whole sort of like, you go through this process, you almost wish you hadn't got involved in it, and then you need to extend the process to try to get the accountability that wasn't delivered. Okay, so the therapeutic innovations and interventions, such as the inclusion of photographs or pen portraits, are variable in practice. These are sort of supposed to be humanising mechanisms, but they are again contested. These small acts of therapeutic jurisprudence included the coroner asking to see photos of the person who died at the end of the inquest, having a named contact, and being treated with respect. These are not, again, these are so easy to do. So I just wanted to say a tiny bit about stories and methods in terms of research, because making a referral to a professional health and social care regulator or giving evidence at an inquest involves telling a story of harm. And these stories are widely recognised. Stories generally in research, particularly in healthcare, are seen as a valuable resource to effect change and benefit clinical practice. Now, our interviews in both projects generated big stories in which a specific group of tellers in an interview setting in which there was minimal research or intervention opened a window to the culture of coronial and regulatory practices by sharing their attempts to generate accountability after experiencing health or social care related harm. Now, these stories are typically retrospective and could be included in the critique of participants being encouraged to narrative unhealthy closed temporal orderings, as Sauls wrote in 2013. Is this a negative experience for participants? Does the storytelling mechanism embedded within a research project provide a way to deal with moment-to-moment adjustments to changing circumstances, small stories, or do they provide a sense of a larger horizon of meaning in which to place the participant self and the possibilities of leading a healthier life going ahead? So what is actually going on within this research setting for the participants? Do we know, do we care, or do we just go across, interview people, take the story and go and use it for our own purposes? So these are quite interesting puzzles, really. And then following Nelson Lindemann again, we suggest the stories that were told to us had a particular purpose, acting as counter stories to repair identities damaged by processes designed to protect public members from harm. And at the heart of these stories, like I say, is suffering. So the interview setting, we are saying, and I think this probably makes me feel a bit better about it, so maybe it's not really true, but was an opportunity for people to share counter stories and redefine and repair their identities. Now, I wanted to say a bit about disrespect, because to me, disrespect is at the heart of all these issues within these processes. And tackling disrespect, Vicky Entwistle up in Scotland has been doing some really beautiful work around disrespect in healthcare. And it's been described as one of the most pressing moral and contemporary problems. It's framed as a social injustice, which involves the failure to relate to people as equals. To be disrespectful to people is saying, I am actually better than you and you don't count. And so it involves a level of superiority which should not be present in health and social care services. It's really problematic. So there's an inherent contradiction or tension here, as regulatory practices are an important mechanism for ensuring professionals are held to account, and yet these processes are just people who have already been harmed. This is very problematic. Okay, so it can be, I'm not going to say that because it gets even more complicated. So there's a clear overlap between, probably more complicated for me than you lot, to me to be sort of like patronising, but there's a clear overlap between being treated with disrespect and testimonial injustice. Not being listened to can compound or amplify initial harm that led to the referral or the engagement with the coronial process. And the use of the term disposal by regulators to refer to cases that are closed without further action adds a further layer of unease here. For Razak, disposability is a mark of subhumanity that inscribes the lives of Indigenous people who have no place in the present. And I think the use of this term in regulatory processes could be interpreted as an example of institutional disrespect. So, okay, I've got few minutes left. Okay, so we found that the processes were characterised by extraction, dismissal, and disrespect. We found that people in the fitness to practice hearings were not kept informed of what was happening. These things could drag on forever. They talked about never being able to ask somebody. They always had this thing like, we can't tell you, it's not your case anymore. And they felt that the ownership of their story had been taken by the regulator, whose sole purpose was to construct a robust case against the registrant who was up being having their practice examined. And this wrenching of this story from participants was really, really problematic for them. And they found that they had to experience adversarial engagement as witnesses, which was very, very upsetting for people. They found that their evidence, their witness statement, wasn't given to the panel as a whole thing, which is what they expected. It was retracted. The charges were changed along the time. They weren't told what the final charges were going to be in the fitness to practice hearing. It was a surprise to them on the day to find that the things they thought were really important about what had happened to them or their family member had been ditched. We found that people were expecting to give evidence and they'd find out 5 minutes before they weren't needed anymore. Somebody was on that line just waiting to give evidence. You can't imagine the stress of waiting to give evidence at a hearing that is so upsetting for you. And you're told to wait by the phone because you're expected to give your evidence at 1 o'clock. And when everybody's having their sarnies, you suddenly get a little message saying, we don't need you now, see you. And you're just left without any thought, care, or follow-up at all. It really is extraordinary. I mean, it's really interesting, the contrasting inquest saying families at the heart of the process. We say it, we don't do it. And fitness to practice hearings where you are literally nothing. You are just there to give and then go away. And what was really interesting was that when people finished giving their evidence, they wanted to stay at the hearing. And this was not facilitated at all by the regulators. And they talked about feeling really out of place when they said, I want to stay and listen to the evidence because this story is all about the harm that happened to me at the dentist or at the doctors or through my child dying. I want to stay. So they were allowed to stay. It's a public hearing, but they were made to feel out of place. And so I think that's, again, really important evidence here. And again, like I say, there was terrible communication and dragging time, which obviously happens in inquests as well. So I'm just going to finish by saying participants enter both these spaces, the coronial space and the regulatory spaces, with the expectation that their story, their personhood matters. These processes are designed to deal with these stories. And yet they don't matter. People don't matter in this. Instead, disrespect is repeated and amplified in feedback loops without any recognition on the part of the various actors involved in the coronial space or within the fitness to practice space. The core focus for regulatory bodies is the construction of a robust case and ensuring the relevant people are in place at the right time, rather than any consideration of the well-being of public referrers. The coroner is seeking to answer a smaller set of questions in relation to the person who died. And while well-being is apparently a central consideration, as I've said, this doesn't always translate in practice. There's an important fracture between the expectation of public referrers and the aims of the coroner and regulatory bodies, both of which hold the power to make key decisions about what is and what isn't included in the hearing and how much the person is or isn't involved. We concluded in the paper we've published the inquest process is inherently unjust and could become a site of further dehumanisation, generating further injustices for families who have typically advocated for their relative in a society in which their value is discounted. Families are forced to continue to undertake considerable administrative and emotional labour at no cost and no support to try to gain accountability and ensure the humanness of their relative is acknowledged. Ignorance about disability and mental health can generate further harm, unsatisfactory determinations, and lead to further accountability labour. Our findings also demonstrate the impact of therapeutic jurisprudence on families and suggest being human, compassionate, respectful, and informed is key in both contexts, and I would say in life more generally. Identities are, however, too often damaged, leading to the need for counter stories for mechanisms of repair. The research interview, when handled sensitively, can provide a site for narrative repair. Sara Ahmed talks about the collective complaints and complaint collectives, and we have in effect in our 2 projects created a collection of testimonies shared in pursuit of improving health and social care, regulatory and coronial processes. Ahmed certainly further describes how complaint can be an expression of grief, pain, or dissatisfaction, something that is a cause of protest or outcry, a bodily ailment, or a formal allegation. Our analysis captures these strands and makes visible the institutional mechanics that both invite and block accountability, which again goes back to the first paper. People are unsurprisingly strongly attached to their stories, and this connection is quite possibly amplified by the harm experienced, the atrocities. Both contexts involve substantial commitment in terms of time and labour on the part of families. Now, we suggest disposability characterises the experience of public referrers and quite possibly inquests. We identified the disposability of evidence, including spoken word, text, and lay case analysis, of witnesses, the deceased person, and of humanity and care. This disposal was facilitated in part by a dispersal of logic by the regulators who shift boundaries about what participants consider to be facts. As Ahmed describes, the ease with which procedures can be bypassed tells us something about the nature of power. The topsy-turvy, upside-down world of weirdness that Ahmed's complete work captures resonates strongly with our analysis. These processes will continue to generate additional harm until disrespectfulness is attended to and genuine thought, kindness, and care is introduced. Thank you.
Thank you, Sara. And kind of hopefully I can ask the first one because I'm going to ask the first question. Sorry. So I found this really interesting and I love the paper you have out on it as well. I just think it's really interesting work. And one of the things I've wondered about, and this might be like too much of the lawyer in me about it, is whether actually what you're describing is just the perfect example of the hard clash between like the expectation and the reality of the legal system, and this invitation to engage being seen as important, right? People want that engagement, but once they arrive in a system that doesn't actually facilitate engagement, and actually they aren't at the heart of it, whether that's what's happening, particularly, that they're being told we will hear you or we will listen to you or something, but then actually once they're there, all of the kind of micro evidence of the experience is that not really though, right? We're doing this as a tick box. And the other thing is the work on coroners in particular, and the attitude of coroners in terms of the approach. So families are at the heart of this. Until then, the chief coroner said, well, they are kind of, right, but they're not too much at the heart of it, because actually what we want to find. And so that attitudinal disposition that then trickles down through the process, like the power, I suppose it's like you're saying, the arrogance of someone to situate themselves. So I just wondered, about those two things. And it struck me in your paper, and it strikes me in what you're saying today.
Yeah, I wonder, because we sort of feel like, well, the fitness to practice process, they've not really considered people as people and well-being of people, I don't think. So they have got work they could do there, and it could improve slightly. You can't say to people, I mean, there was a sense in our project that people were saying, I would never recommend people make a referral because the outcome for yourself is really damaging, which has all sorts of problematic implications. And I think the point, so I don't know what the answer is to that, but I think you're right, the clash is there, and I think it's up to legal people to unpick that clash and try and work out can we actually get these two aspects. And the same with the coronial process, isn't it? That's what you're trying to do. And it does, I mean, it's amazing what a little bit of kindness, how far that goes. So I really do think it makes quite a difference. And people do remember when the coroner came and sat down and just sort of said, your son looks like a really bonny lad or whatever. People take that away and they can keep that for years. So I don't think these things are insurmountable. But the thing you were saying about the coroners, what's interesting is we've noticed, because of the live tweeting by George Julian or the reporting, coroners are beginning to generate knowledge about people with learning disabilities or autistic people. And there was an inquest recently, Miles Scriven, who's the coroner actually appointed an expert in learning disability. It's like a game changer. You've actually got the expert there sort of saying, well, this didn't happen and that didn't happen and this should have happened. And all of a sudden, the coroner's there giving the most damning determination, just because they've recognised they really need to get an expert who's an expert, not one of these repeatedly appointed court experts who literally does it for the massive amount of money and just cut and paste the report that they did in another part of the country with no knowledge at all. And I sort of feel like you shouldn't have these people in these roles of power without critical scrutiny. They really need to be asking critical questions of themselves and then improve the process.
Yeah, thank you. So Ian,
Question about the idea of disrespect, its relation to epistemic injustice. I mean, usually when philosophers talk about testimonial injustice, it's always characterised in terms of failures to give people their proper credibility. But I wonder whether you think that actually the failure to give respect is far more primary.
I do.
That's one way you disrespect someone, you don't give them their credibility.
Yeah. And if you disrespect somebody, you're by the very nature not to listen to them. You've already said I'm actually better than you, so I don't need to listen to you. So I feel like disrespect is something that isn't, and this was Vicky Entwistle's big things. We really should be paying more attention to disrespect. She's talking about in healthcare settings, but I think it's at the centre of so many problematic interactions between public and professionals. So yeah, I agree with you, and I feel like all of us must have experienced disrespect at some point or another, and it really does cut quite deep, doesn't it? It's sort of like, it's quite cutting. And it's, if you experience that in a setting in which you have no power, in which you expect to be cared for or expect to be treated with some sort of thought and empathy, it's brutal, isn't it? It's quite savage.
so Happy.
No, there's only for somebody else.
Yep.
Okay. So thanks very much. I just wanted to ask about the different levels and whether you think some are more generative of this disrespect. So obviously, I think in any sort of legal procedure, there will be a quest for justice, which I think in a lot of cases, like criminal law or personal injury, it's not really necessarily something you can expect or kind of build on in both ways. Then there's also the professional level of the professional misconduct, where you're saying the purpose of the process is to remove people who are unfit to practice from particular professions. And then there's like the epistemic quest, so kind of trying to actually find out what happened and to reveal lies and so on. So do you think they all sort of, sort of cohere together to one picture? Or do you think there's one of the domains where there's more